Everyone, Keith Carlson here from Carlson and Jai Kumar. Wanted to give you a weekly update on some of the cases that we've been taking a look at in recent weeks are coming out. Give you a brief summary. Feel free to reach out to us if you need a little bit more information on any of them. Usually we're focusing in the areas of employment and healthcare, of course, but sometimes there are cases of interest that we'll spot and or that could have ramifications on the employment sector or healthcare sectors down the road. The first one from the beginning of September that we noticed that wanted to bring to your attention was a Title IX religious exemption case. And this was brought by a group of students that were looking to have a different interpretation of the religious exemption under Title IX taken, particularly on sexual and gender minority students, as it was described, bringing this action. The action was ultimately thrown out by the trial court, and that decision was affirmed by the Ninth Circuit Court of Appeals. The background on it is essentially that there is an anti-discrimination provision in Title IX, and there is also an exception that allows religious entities and organizations, including these colleges, to discriminate on the religious background of students so long as it is in the furtherance of the purpose of the entity. So why does that matter in the employment space is because oftentimes Title IX and Title VII, the employment title, interpretations are linked. This matters further in California because oftentimes the PAGA and anti-discrimination statutes in California are interpreted by the courts with an eye towards Title IX and Title VII. So it's all interconnected, and it looks like in this situation, the religious entities, which could in the future include employers, have the benefit of this recent case, Hunter versus Department of Education, to help them in their seeking to further their mission by employing the people that they believe fit their mission from a religious perspective. Another one that has kind of been garnering a lot of attention over many, many years, in fact, decades now, is Simers versus Los Angeles Times. This is a much more classic employment case over the years where a former opinion columnist made claims against the Los Angeles Times for age and disability discrimination, particularly under California's FEHA, the Fair Employment and Housing Act. Up and down it went between his trial courts and Court of Appeal, multiple trials, multiple $1 million in damages sought for his demotion, which he said had to do with his age and disability. Of course, this latest incarnation after Simers' ultimate victory on the underlying issues was on the attorney's fees award, which had been to the tune of $3.5 million, which is believable considering how much it had bounced around in the courts. And that was recently affirmed after the Court of Appeal in California looked at that and agreed that he was owed $3.5 million in attorney's fees. Unfortunately for him, he passed away in June, so that will now be attorney's fees paid to the estate and ultimately his counsel. Nevertheless, maybe after originally being filed in 2013, we have come to the end of the road in Simers v. Los Angeles Times, but we will stay tuned. Two others, both related to Elon Musk, a famous California employer, or maybe a Texas employer now, or maybe a little bit of both. One has to do with Tesla, the other has to do with X. First, as to Tesla, that's Taylor v. Tesla. Last week, another court in California, Court of Appeals again, ruled against Tesla's attempt to dismiss a PAGA, or Private Attorneys General Act, lawsuit against the car maker. This comes from allegations of employees alleging racial discrimination and wage and hour violations in Tesla's Fremont facility. Tesla has argued that it should have been thrown out under California's anti-SLAPP statute protecting free speech and public issues. The manufacturer was saying that the lawsuit was really tied to these broader public debates about discrimination and another related Tesla case. The court found that the workers' claims were focusing on wage records and labor violations and not subject to the anti-SLAPP statute. As a result, it denied Tesla's motion to dismiss, and now that lawsuit will proceed. And this is all part and parcel of some of the cases that have been going on regarding Tesla's labor practices in California and other PAGA-related matters. So we'll keep an eye on that. Last, not an employment case, but does affect X, a large employer in California. X Corp v. Banta, the Attorney General. There, X sued and prevailed. They did this in federal court, and ultimately the Ninth Circuit Court of Appeals upheld a preliminary injunction, and that is going to prevent California from enforcing Assembly Bill 587 from 2022, which is a content moderation disclosure statute that recently went into effect. X argued it violated the First Amendment, compelling disclosure, and the Ninth Circuit decided that that is most likely the case, and it would grant it on First Amendment grounds. So the law is on pause for the time being. So those are some of the big cases we watched in prior weeks, and we'll get back to you with more. Again, feel free to reach out if you have any questions. Thanks. Bye-bye.